Thank you, Mr. Chair and colleagues. Again, this is part of an effort to make the arbitration system more fair, more acceptable to the public, to both the reality and the perceptions the public has when it is required by mandatory binding arbitration agreements to enter into this process. And we know that arbitration is not the flashiest policy topic, but it is probably one of the most important issues in terms of justice and the judicial process here in California. If you have a cell phone, if you have a parent in a nursing home, as we just heard, if you go to the doctor, even if you have a job, you'll likely be controlled by an arbitration agreement. And this committee, as has been mentioned, held a hearing last month when we heard compelling stories from Californians about just how powerless they felt going through an actual arbitration. We heard from an active military member. We heard from a small business owner. We heard about an abusive and largely unregulated system that stacks the deck against the elderly and the terminally ill. When you begin to compare the arbitration system to court proceedings, the arbitration system seems like a veritable wild, wild west of the justice system. Rules of evidence don't have to be followed. Discovery is limited. Arbitrators don't even have to follow the law. That doesn't sound like justice to me. But I understand the reality of case law, and the United States Supreme Court has disfavored attempts to limit arbitration agreements. I hope that the Supreme Court, new Supreme Court, might change some of its attitudes. But in the interim, we have a moral obligation to ensure that our arbitration system is as fair as possible. This bill, Senate Bill 1078, helps to tip the scales of justice back towards fairness. In this bill, I am trying to address the repeat player problem. This is where a company brings the same arbitrator repeat business, which is worth hundreds of thousands of dollars to that arbitrator, if not more. If you are the little guy or woman going up against the company, you're going to think that there is no way you're going to get a fair shake. After all, that arbitrator has 50 cases or more of work ahead of him or her given to them by the other party. How are you going to get justice if that arbitrator rules in your favor? They're not going to have more business. Or at least that is the perception, and one that is not unreasonable to hold. This bill says that the arbitrator cannot entertain or accept additional work from one of the parties to the arbitration while the arbitration is pending, unless both parties agree that it is okay for the arbitrator to take additional work from the party before any solicitation of the arbitrator takes place. So it requires both parties to agree, and if they do, then the arbitrator is free to go ahead and to solicit that work. My bill also gets at a common practice by an arbitration provider organization. Look, let's face it, these arbitrations create a private justice system. And like most private entities, there is a desire to market. And so one of the marketing tools that these providers use is to put on seminars on how to win an arbitration. And they hold meetings with businesses to convince them to hire their arbitrators for future arbitrations. It's a marketing device. In a private sector world, that's not an unreasonable thing to do. But this is still the justice system. And these unsavory practices should not be allowed. And right now, they don't even have to be disclosed. This bill stops arbitration providers from soliciting business in such a manner from a company that is a party to a pending arbitration using one of the provider's arbitrators. Heavens, if I have a distinct advantage to go to a seminar on how to win the arbitration that's being held before one of the arbitrators of this company, doesn't that put me at a distinct advantage? Absolutely, or at least it should. This bill also requires that the actual arbitrator disclose any such activities in the prior 2 years between the provider and the party in the arbitration. Now, this may not disqualify them. This may not discourage one of the parties to continue with the arbitrator if they believe that is a fair and impartial arbitrator. But at the very least, it requires that notice. It requires that that information and transparency be provided. These are the rules that arbitrators are supposed to follow. Excuse me, there are rules that arbitrators are supposed to follow to ensure neutrality and fairness, but there's no accountability. If an arbitrator violates the ethical rules or fails to disclose, there's very little consequence. At best, the little guy or gal can seek to vacate the award. But after you've been through a whole arbitration, at the emotional and financial and other costs associated with that, is that how we want to proceed? The arbitrator, by the way, even gets to keep all the money that they received, even if that arbitration is set aside because they have violated ethical rules or failed to disclose. That just doesn't seem fair. This is really unjust enrichment. So this bill requires the provider organization to return the money if the service that their arbitrator provides results in vacature because of an ethical violation or other misconduct. Now, before I turn to my witnesses, I would like to note that we have received some opposition to this bill. And while I'd like to further review the opposition, some of which I got as late as yesterday afternoon, I am certainly willing to clarify the following. First, insofar as the bill requires that the arbitration company refund the costs, I will clarify the bill so that the costs of the arbitration have to be returned by the party who received the costs, whether the arbitration company or the arbitrator, him or herself. That seems to be a fair and reasonable request. And second, there have been concerns raised about the bill requiring costs to be returned where the award has been vacated. And I'll clarify this provision to ensure the costs are only returned in those circumstances where the arbitrator has been removed or the award has been vacated due to violations of ethical and disclosure rules. With that, members, I would respectfully ask for your aye vote, and we'll turn over the proceedings to my witnesses in support, Cliff Pilevsky, a partner in McGinn, Hilsman, and Pilevsky, and Elise Sanguinetti, the president of the Consumer Attorneys of California.
Thank you very much. Cliff Pilevsky on behalf of the California Employment Lawyers Association. I want to provide some additional context to Senator Jackson's remarks. No justice system can succeed without the confidence of its users. As a result of this legislature's efforts in the early 2000s, the Judicial Council passed a set of ethical rules, many of which are really good and very important. The most important are you have to disclose all past, present, and future cases. You can't have ex parte contacts with an arbitrator during the arbitration. And the third rule said that an arbitrator cannot, during the pendency of the arbitration, act as a lawyer, expert, or consultant for any of the parties. Those are great and critically important rules that enhance the integrity, the perception, and the utility of arbitration. But there's a gigantic hole in those rules that this bill will fix. Right now, as it stands, if an arbitrator on their multi-page disclosure form checks a box, they are allowed to then take as many cases as they want from parties and lawyers to the arbitration, and the other party has literally nothing to say about it. This has led to what I believe to be legal atrocities. I've been contacted and I'm aware of, and the New York Times has written about instances where after an arbitrator was appointed, the arbitrator has taken in one case 30 additional cases, in another case 40 additional cases from one of the parties or law firms. Think about that. That's hundreds of thousands of dollars. As a lawyer, I try to be the most ethical person in the world. It would never occur to me to offer additional business or compensation to an arbitrator on one of my cases. It would make me feel dirty. I cannot believe that arbitrators in this state see no problem and will take up to 30 or 40 cases. Some of the opponents, and in particular, I'm a bit disappointed in the CDRC, who has done a good job over the years protecting the integrity of the process. Some of the opponents say, look, if you get a checkbox and you know the arbitrator will consider additional cases, choose someone else. Well, let me tell you, you can't do that because both JAMS and ADR services check the box and mandate that their arbitrators check that box. So if you are sent to JAMS or AAA, you don't have the choice to choose an arbitrator who will follow the ethical rules and not do things which will lead a reasonable person to entertain a doubt of your impartiality.
Thank you, Mr. Pilesky.
Good afternoon, Mr. Chair and the rest of the committee members. My name is Elise Sanguinetti. I am the president of the Consumer Attorneys of California, and I'm here in support of SB 1078. This bill is really about transparency. It is about making sure that two parties, when they go into arbitration, know what they're getting themselves into. Senator Jackson already talked about the unfairness that can occur in arbitration. And I know that this committee is well aware of those issues, considering the hearing that occurred last month. But this bill is really one small step to try to address an issue in a very narrow way. The reason that that's so important is that I know that some of our opposition will come forward and say this may run afoul in some way of the FAA, the Federal Arbitration Act. It may be preempted in some manner anytime that there's any changes to the arbitration system. Those are the complaints that we hear. But the reality is this is a very, very, very narrow issue trying to address a transparency problem and to put out in the open if there's conflicts of interest. And that is something that as lawyers that we have to abide by our professional code and that arbitrators should have to abide by as well. So the Consumer Attorneys of California ask for your yay vote in support of SB 1078. Thank you.
Thank you, Ms. Sanguinetti. Any other witnesses in support?
Good afternoon. Aaron Lewis for the Consumer Federation of California in support. Apologies, we're not on the analysis, but appreciate the opportunity now. Thank you.
Any other witnesses in support? Any witnesses in opposition? Have you flipped a coin to decide who goes first?
Yeah, we did, and I lost on it.
Okay, congratulations.
Well, thank you very much for the opportunity to speak. My name is Paul Dubow, and I'm the legislative chair of the CDRC. First of all, I do appreciate the fact that Senator Jackson has clarified proposed subsection D of the bill. I was to make some comments about that, since I hope that we could have some more conversations to see what's happening. I'm still a little concerned about that because there is no bright line with respect to what should be disclosed and what should not be disclosed. Obviously, there's some things that obviously should be disclosed, and you wonder why they're not disclosed from time to time. But there are other things that are very close, and I think there should be some procedure to determine whether the act of the arbitrator in not disclosing this matter was egregious. And I would suggest that you think about that at one point or another. I'm also concerned about how it will be carried out. For example, the provider is liable for the acts of the arbitrator who's not an employee of the provider. In fact, in some cases, the arbitrator may not even be on the roster of the provider because the parties have chosen the arbitrator. And so that is a problem. And at the very minimum, it would seem to me that the provider would have to be an indispensable party to the motion to vacate because the provider may very well be liable for the reversal of the arbitration. So these things have to be considered. But I'm looking forward to having further discussions on this. So I will go on to the other issue of the amendment of Section 12. First of all, I want to clarify.
You've already used 2 minutes. Maybe you could summarize your last point.
Can I just talk about 12 then?
I could take it away from the other speaker's time, sure.
Absolutely.
Okay.
Okay. Well, basically, I want to correct what my dear friend Cliff Pilevsky said. The AAA does not check out. It's not true. He's incorrect about that. James, he did inform me that James did it. I didn't know that until I saw Cliff this morning. And but even if that's the case, the lawyer for the party, or the party if he's unrepresentative, can disqualify the arbitrator. So if James decides, requires all its arbitrators to say that they're going to go ahead and take other cases, they still could be disqualified. And if James wants to pursue that, every one of their arbitrators will be disqualified. But the problem is that there's only a minor difference with the proposed rule and the current rule. The proposed rule requires the matter to be decided beforehand. The current rule is after the arbitrator is appointed, and he or she tells the parties that I want to take more cases. If you do it beforehand, the parties don't even know what the arbitrator is going to do. They're deciding something that the arbitrator hasn't told them what he or she will do. And the fact is, in my personal experience, I've been an arbitrator for 16 years full-time. More often than not, it's the plaintiff attorney who has solicited me for a second case. In fact, I have never been solicited, it's my personal experience, I have never been solicited by the corporate defendant. Every time I've been solicited after I've agreed to take a case on, it's the plaintiff attorney. And the reason for that is that I, like my fellow arbitrators, are thoroughly vetted by the parties through the disclosure procedures. They know, okay.
You've just eaten into Mr. Dassinger's time, so I don't know what to tell you. Hal, I'm sorry.
Urgent no vote.
Okay, thanks. Are there any other witnesses in opposition? Thank you, gentlemen. Senator Jackson, would you like to close? Oh, we have questions. I'm sorry. We start with Senator Hertzberg and then Senator Monti.
You know, Madam Chair, I completely agree with your statement that we've got this horrible system of private justice, and as you know, we worked on this, I don't know how many years ago, and set the operation in place for these important Judicial Council standards on the excruciating bill, we called her, as the chairman of Judiciary Committee in those days of this House. And so it's the right thing to do. What I'm concerned, and look, you know, all the stuff on the arbitration stuff, I completely agree. You know, it's ridiculous in terms of what's happening. It's draining our courts. Judges are going and taking the seat. They're begging you to help write a letter of support. 5 minutes after they get in the bench, they're getting out doing private judging because they can make a ton of dough. Okay, come on. It's ridiculous. It is ridiculous. But what I don't get is, how does this bill solve the problem? Because what's happening, and I don't know if I understand it, I'm trying to understand it. You got JAMS and these other big companies. They go out and put all the judges on the tick. They put them all on their list, right? That's how it works. They go out and they're trying to promote their business. On the other hand, they don't really have a list of who's doing what. The ethical standards, like a lawyer, applies to the individual judge or arbitrator who's arbitrating the matter. Right? So now what you're doing is, if I understand this correctly, I need some help on this, I may have it wrong, is telling these big companies, well, you know, you guys can't do this marketing. Well, they're always going to have cases before them. That's their job, to keep their dockets full of stuff, right? It is completely accurate, in my judgment, based upon all the homework that we've done over the years, is that there are people that like forum shop, judge shop, to find people that will help them. There are judges, I would strongly suspect, that are out there that throw cases in a way that, or rule in a certain way, ethically, they have a certain bias about a certain thing, and they get picked. All that's true. I'd throw the whole damn thing out if it was me. But if we can't, as you suggested in your opening, I don't know how this solves the problem, because what you're doing is you're putting the thumb screws on these companies and saying, this is how you can't advertise. And it hasn't passed the smell test, because I've seen all those ads. I've seen how they work. But, you know, and you're creating more liability and more risk and more people in the process. but do we really get to the underlying issue? We did it back with the ethical standards, and that was pretty smart. But now, basically, unless I have it wrong, you're applying those ethical standards to the companies that have a relationship with all these arbitrators to say, you can't take a case. Well, you're basically shutting them down, as far as I know. I mean, unless I have it wrong. No one talked to me about this one way or the other. I've just been around the business for a long time. It's been a real important issue to me, and that's kind of what it looks like.
Let me try. This bill does not in any way prohibit solicitation. So if that was your operating assumption, it doesn't do that at all.
But if you have a pending case,
well, that's already in the rules.
but that's as to the individual as opposed to the company.
That's right. But here's
That's
the
a different standard.
Let me explain why this has come about. From 1977 until 1984, there was an ethical code created by the ABA and the American Arbitration Association.
Right.
Rule 1 says it is unethical and inconsistent with the ethics of arbitration for arbitrators to solicit cases for themselves.
Correct.
Rule 1. It said you can have an advertisement or general availability. Once we had these for-profit providers, the arbitrators were simply paying marketing people,
right,
non-lawyers, non-judges, to go out and to say things and to do things which they can't do themselves.
Right.
If you can't do it yourself, if you're a lawyer and you can't solicit cases, you can't pay a capper or a runner to go get it for you.
Against the law.
That's right. All we're doing here is saying that if an arbitrator can't solicit cases, then if there's an obligation imposed on the arbitrator and the provider to avoid doing things that creates an appearance of impropriety.
Doesn't that get to the question I asked? If on the one hand, Rule 1 from 1977 says you can't solicit yourself and you got to hire a marketer, and now you're telling your marketer can't market.
No, it doesn't say you can hire a marketer. The concept was you shouldn't. You do business by putting an ad in the paper and by promoting your resume, your credentials to the public. You can't go up to a law firm and put on a private seminar.
Doesn't that, for the third time, and I'll finish here, put these people out of business? I don't care.
No, it doesn't put them out of business.
Hold on.
It makes them ethical.
Wait a minute. If my job is, my name is Robert Jackson, just related to the chairman of the committee, just to make it meaningful. And I went to law school and all these fancy schools, and I have all this experience. I can put an ad in the paper that says, hire me as an arbitrator because I have these great experiences, and I've handled 100 of these kinds of cases involving this subject matter. But if I work for the Judicial Arbitration Management System, JAMS, I hire them to do that for me.
That's fine.
Right? But they do it by putting on these verstunkene deals that Hannah Beth that the chair talked about. So the question is, it's getting to the point you're putting them out of business.
No,
maybe that's the right thing to do. I just want to call it as we see it.
Senator,
If I may.
Yeah, help me out here.
First of all, I'm sure they would argue they're not verstunkenen, but I can't speak to that.
I'm sure you're correct.
But the point is, that solicitation includes an oral or written request for arbitration business, but does not include advertising directed to the general public. It's if, let's say, the firm of Hertzberg and Hertzberg is in the middle of an arbitration, and some arbitration organization puts on a seminar for the attorneys and staff of Hertzberg and Hertzberg telling you how to win an arbitration while you have an arbitration pending. This is a problem. This is the problem. If you're going to do something through one of the CEB or CLE, whatever they call them now, continuing legal education programs, that's open to the public. That's a different issue.
Well, just follow up to Claire's, and I'll finish here. Let's assume we have a firm of Jackson and Hertzberg, and me and you are partners.
Sounds like a deal. Let's quit this job and go make some money, right? No.
And Jackson and Hertzberg are co-counsel on a case involving ABC Co. Now we're involved in that case. We happen to also be signed up with whoever the arbitrator is signed up, and JAMS goes and does one of these seminars, and the seminar is how to win a case, but doesn't talk about Jackson and Hertzberg, just how to win a case. But we're affiliated with JAMS because we're signed up with them.
You just have to disclose it.
Or agree to it. Nobody's going to agree to anything. That's the issue. It's going to shut down the business. I mean, I think the practical effect is going to shut down the business or severely limit how they do business. I'm not suggesting that's the right thing. I just don't think that we captured that here in terms of.
Well, certainly the goal is not to give an undue advantage because of these kinds of proceedings. And we don't want, as part of the program for a company, whether, and I don't want to single out jams, to say, and as part of this proceeding, we're going to give you a heads up on how to win a case that you bring to our arbitrators. That's what we're trying to avoid.
Okay, now we'll hear from the firm of Monning and Monning.
Yes.
Or as I used to call it, me, myself, and I. And
LLP.
yes. So I find this area fascinating. I'm a lawyer. I've run mediation programs. For the non-lawyers, I think it's important to be clear. Unlike mediation, where a skilled mediator helps the parties reach an agreement or not in a voluntary process, an arbitrator, through the arbitration agreement, is given the authority to render a decision. In most cases, that's not an appealable decision unless you can show fraud or some other illegal conduct. So the arbitrator, if it's between a giant corporation and a consumer, or between a resident of a nursing home and a nursing home corporation, depend on the integrity of that arbitrator to hear the case, to weigh the facts, and to render a decision that will be a final, and in most cases, a binding decision. To me, it offends the sensibilities to think that any party to that arbitration could, during the course of that arbitration, in a sidebar, during a coffee break, offer that arbitrator another case or cases. Mr. DeBow raised the concern of, well, how do you measure if it's egregious or not? For me, the very problem is, how do you measure? It's egregious if it happens, in my view, because the arbitrator can say, well, it didn't influence my decision in this case. But an arbitrator, just like a judge in court, has to make determinations of gray areas, of not just a factual finding that this is a document, this is the birth certificate, and make a factual finding. Arbitrators, like judges, evaluate credibility of witnesses. They weigh in with their skill, their experience, and their subjectivity in reaching a decision that has profound impact on the parties and on society by extension. So if within that process you have people offering future employment, I don't see how it certainly doesn't pass the whiff test. It creates a perception of impropriety. If I'm the unrepresented consumer in that arbitration and I hear a corporate attorney talking with the arbitrator about my calendar's free for the next 3 months, and great, thanks for letting us know. I think there's going to be some business for you. If I'm the consumer litigant in that arbitration, I'm going to think, boy, this is stacked against me. And it may not be. That arbitrator may be able to separate the perception that was created in his or her decision. But my view is what we're trying to do here, and it may require some fine-tuning, because what I think should be prohibited absolutely is any discussion of future business between any party and any arbitrator during the course of that arbitration, within that arbitration. I think it gets tougher if that arbitrator is on a JAMS list. I don't think you can say that JAMS shouldn't be able to advertise the availability of this arbitrator during the course of that arbitration. But certainly, and I don't think that's what the author is suggesting. So again, this isn't really a question. It's just kind of a statement. I'll just close by saying, when I was in the Assembly, I carried a bill that is now law that does not allow the parties to an arbitration to waive the arbitrators revealing any potential conflicts. Like I play golf every week with the person representing the company that you're in arbitration with. What used to be a practice was an arbitrator would say, do the parties agree to waive disclosure of conflicts? And maybe the more seasoned arbitration lawyer in there would say, sure, we have no problem. Again, the unrepresented litigant, this is, we always waive this, uninformed. So the law that is now California is the arbitrator cannot waive a disclosure of conflicts. So that is law. And I would argue that this adds the next prong to that, which says during the course of that arbitration, neither party nor arbitrator should be able to negotiate or discuss the prospect of future business and future arbitrations. That's how I read this bill.
That's correct.
For that reason, I'm supporting it, and I will turn that into a motion at the appropriate time.
Okay, so we have a motion. Senator, does your partner have a question? Senator, does your partner have a question to ask?
Let me check. I think we're good. Thank you.
All right, any other questions from my colleagues? Senator Jackson, would you like to close?
Thank you. A robust and important discussion. I want to emphasize the fact that I know a number of these arbitrators. They are of the highest integrity and the highest competence. And this is not in any way an effort to cast aspersions on those folks that we all know who have served their communities well as judges, who have retired, who have sought out on occasion or as a career working for these arbitration associations. I know many of them, and they are absolutely above reproach. As was mentioned earlier, a great deal of this is the public's perception. And I think it's critically important, and the only way I believe that a democracy actually is ever permitted to exist and flourish is if people have confidence in the three branches of government. And certainly the judiciary is one of those branches. These are not generally people, although we do elect them every 6 years or so. We don't really know much about them. They are, we expect them to dispense justice fairly. And now that we have this mandatory binding arbitration system, this is not when people voluntarily go to someone and say, can you help us with our problem? You are required under the terms of these contracts, which the Supreme Court has said are generally speaking inviolable. In most instances that I'm aware, you don't really have a choice whether you agree to a contract and delete provisions regarding the binding arbitration agreement. In many instances, you don't even know they're there. Last time I went to get a telephone, a cell phone, they hand out a strip of 20 pages long of the rules and regulations and contractual duties that you have agreed to. They're virtually not in English, and as a lawyer, I'm not going to spend the 3 hours it takes to figure out what the heck I did. I just bought myself a cell phone. But the fact is I bought that cell phone, and I bought a required mandatory binding arbitration agreement. If that's the way the courts are going, then we've got to make sure that that perception that the public has about the integrity of that system is not violated. And with that, I promise to continue the discussions. As again, I think the spirit of this legislation is to make sure that we do not impede the system that exists, but we make sure that it meets the highest expectations and ethical requirements that the public deserves. And with that, I would ask for your aye vote.
Thank you, Senator Jackson. We have a motion from Senator Monning. Did that come as amended? Did I hear that you had an amendment to the bill? No? Okay.
The concerns came in yesterday.
Okay.
And I did indicate in my opening that there were a couple that I agree with right off the top, and I will continue working with these folks to get it right.
Thank you. Madam Secretary, why don't we read the roll?
The motion is due pass to the Senate floor. Jackson? Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, no. Hertzberg? Hertzberg, aye. Leno? Leno, aye. Monning? Monning, aye. Wachowski? Wachowski, aye.
That's 6-1. Okay, that passes. That brings us now back to Chair Jackson.